You're watching The Legal Breakdown. All right, Glenn, we look at this Supreme Court decision granting Donald Trump full immunity if he returns to office, and it was wrongly decided. That much is clear. It is nakedly, dangerously unconstitutional. So the first question I have is, I think, the most important. While this ruling might be the law of the land now, is it permanent? And what examples from history do you have to back that up?
You know, no Supreme Court decision is ever permanent. There is the concept of stare decisis, a fancy way of saying the thing has been decided. Once a thing has been decided, ordinarily the thing is the interpretation of the Constitution. What it means, once it's been decided, then moving forward, it's supposed to be entitled to deference. When future Supreme Courts take up an issue that has already been decided, where there is precedent, they're supposed to respect it. It doesn't mean they are absolutely obligated to blindly follow it. And in our nation's history, we have moved forward in any number of ways. You can go back to the 1800s, the Dred Scott decision, which said, black slaves could never become citizens of the United States, whether they were born here or not. It took 20 years for the Supreme Court to think better of it. It was actually the 14th Amendment which did away with that horrific precedent. You then move forward in time to a case like Plessy versus Ferguson. People will probably remember the whole concept of separate but equal, which, make no mistake about it, Brian, that was government-endorsed, government-sponsored discrimination, segregation, but at its core, it was discrimination, separate but equal. We all know that the separate accommodations for blacks were never equal. And it took some, 58 years or so for the case of Brown versus Board of Education to reject Plessy's horrific separate but equal doctrine. Then you have the Korematsu case, which is when we were putting Japanese Americans in internment camps. The operative word there was they were Americans, but because of their national origin, their ethnicity, we were dumping them into internment camps during the time of World War II. It took about 45 years for that case to be, overturned and thrown into the dustbin of a racist history of the United States. So the good news is there is hope that this Supreme Court opinion, kind of aptly called Trump versus the United States of America, has a ring to it, doesn't it? Donald Trump versus the rest of us, the United States of America. It will end up going the way of Dred Scott, Plessy, and Korematsu, in my opinion, and I have heard a number of constitutional scholars offer that same opinion. Of course, the big ticket question for those of us living in 2024 is when? How long will it take? I say this a bit tongue-in-cheek, but we only have about 4 months until the next presidential election. And are we going to be laboring under a Supreme Court opinion that in and of itself is lawless? The reason I say it's lawless is because it actually contradicts the express language of the Constitution. There have been constitutional scholars who have said the Supreme Court literally repealed parts of the Constitution, and I've also heard it said, and I agree with it, that this opinion says that the Constitution is unconstitutional. Doesn't make any damn sense. It's illogical, and so it will fall. But the question is, how quickly, can we get to a point where, the powers that be realize that this is not the America that our founding fathers envisioned, or the America we want to live in, where a president is lawless. A president can commit all the crimes against the American people that he deems, fit, or he can order members of his executive branch to commit crimes against the American people and then pardon him because he has absolute pardon power and absolute immunity for any crimes he commits, as part of exercising that pardon power. Do we really want to live in that kind of America? And if so, for how long?
Well, here's what I would offer up. First of all, nothing is going to change as long as the composition of this Supreme Court remains the same, unless, here's the only instance where I can see some change actually happening. We have a Democratic president who actually avails himself of these powers. And granted, it's not going to be Joe Biden. We already know that. We know who he is and how he comports himself. But if we did have any Democrat who came in and just availed himself of these newfound powers and wielded them against a Republican, I guarantee you that never before would you see these jurists scramble to overturn what they had just wrought onto this country. But short of that, which I don't think is going to happen, just given inherently how Democrats operate, short of that, I think that we would have to wait for the actual composition of the Supreme Court in and of itself to change. But here's the broader question that I have. Historically, it took way too much time to correct these massive wrongs. I mean, between 20 and 60 years. But I have to believe that the days where we literally didn't acknowledge the humanity of Black people and Japanese Americans, like, we're a world away from where we were then today in 2024. So do you think that the length of time that it'll take to correct this will be exponentially smaller, given that we're a different country than we were in the late 1800s?
I would like to say yes. Part of constitutional interpretation involves evolving societal norms. And I think that is what has given rise to changes in the law, mainly for the good, like recognizing the equality of all people, recognizing the sort of autonomy that we should have over our own bodies and our own personal decisions. But then when I say that, our thoughts jump to the Dodd opinion, which revoked women's constitutional privacy rights that had been in place for 50 years. So it seems like, we've gone from evolving societal norms to devolving societal norms when we're trying to claw back rights that Americans have had for decades. So I bring that up because in trying to answer your question, I would love to say, oh, you know what, this one will not stand for the 58 years that Plessy versus Ferguson's separate but equal stood. But, I think your point that you made initially is a really good one. Maybe what it will take is a Democrat, a president, who will say, okay, Supreme Court, be careful what powers you've given me, because I will now exercise them to address sort of grievous wrongs to our democracy. For example, Donald Trump just came out in favor of military tribunals to prosecute Liz Cheney. Why? Because he claims Liz Cheney is an enemy of democracy. Well, any thinking person, anybody who has kept up with, legal and political developments, know that Liz Cheney is actually a defender of democracy. But Donald Trump, words and truth mean nothing. He will label somebody who was fighting for democracy as an enemy of democracy, and then he will use his newfound power of, presidential immunity to prosecute those enemies of democracy at military tribunals. Here's the thing, Brian. There are people out there who actually are enemies of democracy. They are residing in Congress. Some of the representatives who asked for pardons. Why? Because they knew they'd committed democracy-busting crimes on and around January 6th, and they wanted to get away with those crimes. That's why they asked for pardons. Those people can correctly be characterized as enemies of democracy. And this is going to sound like some kind of heresy. But, you could also say that Supreme Court justices who ruled in a way that renders the Constitution unconstitutional, they have actually become enemies of a free and fair democracy. Now, does that mean we should encourage a president to just go ahead and hold military tribunals and prosecute the Supreme Court justices? Maybe. But we know Donald Trump is going to do it. So the thought experiment goes, should a Democrat do it for the right reasons to save democracy when we know Donald Trump will use these newfound powers for the wrong reasons to punish his enemies? These are philosophical thought experiments that there is no good answer to right now.
Let's finish off with this. Let's say we're at a point in the future where we are able to flip the court, or at least we have a pro-democracy majority in place on the court, where we know that it's finally the time where we could bring this back up to challenge the precedent that's been established in Donald Trump versus the United States. Would a president then have to do something to actually have grounds to challenge it? So would we need a Democratic president, for example, to abuse this power or avail himself or herself of this power so that they have grounds to actually challenge it in court? Because without that, you can't just bring precedent back without someone actually having been harmed. Is that correct?
That is correct. You need a case or controversy for the Supreme Court to take up an issue and revisit an issue. You can't just say, listen, we think this was wrongly decided, and a year later, we want you to reconsider it. There is no legal vehicle to do that.
So in theory, you would need like a Democratic president to grossly abuse the presidency so that there is grounds to bring this case forward. I mean, you would really need a Democratic president to put him or herself in legal jeopardy by doing something that could then be overturned at the Supreme Court. I mean, doesn't it seem a little bit bizarre that the only way to actually overturn this is to put somebody in enough legal jeopardy, having done something so egregious that they then put themselves on the line as a kind of martyr to get this thing overturned?
Yeah, none of this is normal, Brian. We're living in the legal upside down, and to say a Democrat ought to sort of test the presidential immunity waters by committing crimes and then arguing that he should be held accountable for those crimes because presidential immunity shouldn't be a thing. But there's another way to go about it. It's to have Congress pass laws, because that will often then bubble up to the Supreme Court to decide whether the laws are constitutional. One of the laws I think they should consider is cabining the pardon power, putting additional restrictions on the presidential pardon power so it can't be abused and used lawlessly the way this Supreme Court opinion has just suggested it can be. Or maybe passing statutes that say, presidents are not immune from criminal prosecution. There are laws that could be passed that could make inroads, I think, on this absolute presidential immunity insanity that the Supreme Court just handed down. That would be another vehicle to get the issue back in front of a future Supreme Court.
And it's interesting that we have to have a statute passed when Article 1, Section 3, Clause 7 of the Constitution already says that judgment in cases of impeachment shall not extend further than removal of office and disqualification to hold any office in the future, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. So this is already in the Constitution, that a president who commits criminal acts is subject to any statutes that would be applicable in violating those criminal acts. But, this is the world we live in, where apparently even the plain text of the Constitution isn't enough, which we've seen time and time again.
And Brian, what you just cited was also picked up on by really one of our foremost constitutional scholars, Professor Akil Amar. He teaches at Yale, and he said, by virtue of granting absolute immunity against prosecution, when you look at the language that you just quoted from the Constitution, the impeachment judgment clause saying a president can still be prosecuted even after being impeached and convicted by the Senate, by their action, the Supreme Court has repealed or nullified, certainly contradicted that language in the prosecution, which led him to say they have ruled that the Constitution is unconstitutional. Again, it makes no damn sense.
Well, look, I think it's important that, we continue to focus on this. Look, our goal here for those watching right now is to make sure that it doesn't take 20 years, 45 years, or 58 years, as was the case in these other wrongly decided Supreme Court decisions. That as soon as we have a Supreme Court that is a different composition here, that is a pro-democracy composition, and as soon as we have Congress that's able to pass some law, then we can see this wrong be overturned. And we will continue to fight to make sure that it happens sooner rather than later. So with that said, for those watching right now, if you want to follow along, please make sure to subscribe. The links to both of our channels are right here on the screen. Glenn's channel here is almost up to 1 million, so if you're not yet subscribed, please make sure to subscribe to Glenn's. And of course, this channel is on its way to 3 million, so if you're not yet subscribed to this one, please make sure to subscribe. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.